Good morning. Good morning. It is Friday. We have made it to the weekend. It's Friday, y'all. This week has flown by. In fact, this whole year has flown by. I just cannot believe that we're in the last 2 weeks of October. It's just crazy. Just crazy, crazy. Anyway, um, a jury has been seated for the Sarah Boone trial. Today, this morning, they'll start with the opening statements from the attorneys. So, um, but there was a little bit of heated action yesterday in the courtroom. Um, so I'm gonna play this from a news station as we're waiting for the trial to start and everything, and then we'll talk about that. So let me get this going.
Has just been seated in the trial of Sarah Boone.
Hang on. There.
We have some breaking news out of Orange County right now, where a jury has just been seated in the trial of Sarah Boone. Boone is, of course, the woman accused of leaving her boyfriend to die zipped up inside a suitcase during a game of what she's calling hide and seek. Lawyers for Boone say she does plan to testify in her defense. Opening statements are slated to begin tomorrow.
All right, let's see. Let me get that out of my ear. I don't need to hear that. Um, let's see what this one is. That one wasn't. That one wasn't much at all. Let's see what this one gives us. Oops.
A zipped up suitcase is set to stand trial. Opening statements start this morning at the murder trial for Sarah Boone.
And it comes as we learn some new information in the court about what prosecutors say really happened on that day back in 2020. News 6's Mark Lehman joins us now in studio. And Mark, what can we expect to hear as the trial continues?
Well, there will be two very different versions of what happened from each side. Boone's attorneys claiming self-defense because of prior domestic abuse. The state, though, revealed essentially a bombshell yesterday, saying Boone beat her boyfriend with a baseball bat while he was locked inside the suitcase. Now, after 4 days, a jury has now been selected in the trial against Sarah Boone. She's facing second-degree murder charges after investigators say she zipped her boyfriend, George Torres, in a suitcase where he suffocated. Boone told detectives the two played a drunken game of hide-and-seek inside their Winter Park apartment. Her attorneys plan to use the battered spouse defense and say Torres could have let himself out of the suitcase. Now, in court yesterday, prosecutors revealed new testimony from Boone where she said she not only locked Torres in the suitcase, but also hit him with a bat while he was inside.
We now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth.
Now, it was revealed those remarks from Boone were made in front of a doctor at the Orange County Jail. The state says they'll be presenting that to the jury, but the defense says that's a mischaracterization of what was said. Boone's attorneys also say she plans to testify in her own defense during the trial that's expected to last 3 weeks. Opening statements get underway at 9 this morning, and we'll stream those live on clickorlando.com.
Truth, the whole truth, and nothing but the truth will help you God?
Absolutely.
Welcome to Vinnie Politan Investigates. I'm Julia Janae, filling in for Vinnie. And the subject of our investigation is Sarah Boone, a woman accused of killing her boyfriend with a suitcase. The image of Jorge Torres shocked the public. A man zipped up in luggage, unable to get out despite his furious attempts, while his girlfriend recorded it all with her cell phone and taunted him as he struggled to get out. Here's the story. On February 23rd, 2020, Sarah Boone and her boyfriend, George Torres, were spending an evening together at Sarah's home. The couple had a bit of a tumultuous past. Both had been arrested on domestic violence charges, but they always seemed to get back together. On this night, the two were drinking. But what happened next is inexplicable. George got inside of a suitcase that was then zipped shut. Why and exactly how he got into that suitcase is not 100% clear. But what is clear is that at one point he wanted to get out. He pleaded with Sarah to open the suitcase, but she refused. Instead, she turned on the video camera on her phone and started to record as George begged for his life. Still, she refused to unzip the suitcase. Then the following morning, she eventually called 911. She said she and George were playing hide and seek, and George ended up in the suitcase. When police responded, they found George dead in that luggage. Sarah has been charged with second-degree murder, and she claims she was the victim. She's claiming battered woman syndrome. What happened inside of that apartment, and why was George in that suitcase? Now, since the beginning, this story has revolved around the suitcase video. It's not every day where we have a case where the defendant filmed this alleged murder that the person who's on the stand, who's going to be testifying but is charged with this murder, second-degree murder. And due to its graphic nature, it was named as one of the two reasons that law enforcement believed that they had probable cause to charge Sarah Boone with second-degree murder. It's likely going to be the hardest obstacle to overcome when convincing the jury of Boone's innocence, which is what the defense is going to try to do. In order to truly understand this case, it is crucial to watch the video. But I do want to warn you before we show it, the footage is graphic and hard to watch.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
That's on you.
Sarah.
Real or ransom. I want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you drink on me.
Sarah.
You.
Breathe, Sarah.
Yeah. You should probably shut the up.
Sarah.
This is evidence that's never easy to watch, no matter how many times we play it here on this show. And you can hear not only Jorge Torres, his pleas for help. That alone is enough to feel horrifying. But then to see and hear that Sarah is taunting him and not doing anything about those pleas for help. This jury is going to have to understand what George Torres went through. The prosecution wants to make that clear for this to rise to not manslaughter, but second-degree murder, that she had a reckless disregard and depraved heart for his life. So just how traumatic were Jorge Torres's last moments? That's our question at the top of this hour for the show. And we have experts who are going to talk to us about what it was likely like for this victim. So to help us answer this question, let's bring in our experts. Joining us now, psychotherapist and CEO of Life Counseling Solutions, Dr. Janie Lacey is with us, and also joining us, forensic death investigator, professor of forensics at Jacksonville State University, and host of the Body Bags podcast, Joseph Scott Morgan is here. So Dr. Lacey, let me start with you. We're talking about how mentally and psychologically this could be quite traumatic for someone. What do you think about when you see a video like this?
Well, you're absolutely right. It's heartbreaking to watch, as we know that we are watching the last moments of Jorge's life. But when we consider, especially the reports that are coming out, and you take into context probably what happened to him before she turned on that video. So if there was already some types of discord between the two of them and what happened, that he got into that suitcase, all of these answers that are yet to be answered. But we know that he was suffering. He was pleading for her. He could not breathe. And she's on the other side, taunting him, finding it funny with her slurred speech and bringing back some of the retaliatory statements of things that she feels like that he's done to her, and to sit there and to hear him plead for his life. So we know he was suffering. There probably was a lot of fear, and especially depending on what was happening between the two of them before she actually filmed. All of that stuff really matters to what he probably was experiencing inside that suitcase.
Dr. Joseph Scott Morgan, let me ask you about the physical part of this, because we're understanding what he may have been thinking about, but what was this like for his body to be inside of that luggage?
Well, he's in a contracted position. Let's keep in mind that when they originally released the cause of death, they talked about suffocation. Let's be more specific than that. This is a positional asphyxiation. So what that means is that, as demonstrated in the suitcase in this horrific video, he's in a contracted position. So his arms are pulled in, knees are pulled up, and he's inside of the suitcase that is probably not gas permeable. So that means that you don't have a lot of inflow of oxygen. And so with every respiration that he takes, he is taking in the remainder of the oxygen that is in there, and then he expels the carbon dioxide. And here's one of the things that happens. You develop a condition called respiratory acidosis, which comes along with this idea that your uptake of carbon dioxide is outpacing your uptake of oxygen. It's very painful. He would have gone through these stages of shallow respirations. He still has an awareness. He has enough of awareness where he's begging for his life. You can hear in his voice that he's distressed. And here's one interesting thing that she said that really stuck out to me. She actually said something, and I'm paraphrasing here, but I heard in the recording, he's talking and asking her to let him out. And he's saying, I can't breathe. And what does she say? She says, well, I guess you ought to be quiet. That goes to depraved indifference, perhaps, because she has an understanding the more you talk, the more oxygen you uptake. Therefore, he's on the road to death.
And that's what prosecutors are going to be emphasizing. How much did she understand about the dangerousness of this? And to really understand it, we want to look at this timeline, because we just showed you, it felt like a long time when we watched that clip, but it was 2 minutes long. That's not anywhere close to how long he was inside of that suitcase. So based on the documents that we have looked over in this case, we were able to put together these key times. And that includes, we have the arrest affidavit. It states that the first video where she began recording was at 11:12 p.m. And then she decides to go upstairs a little over an hour later and fell asleep after about 30 minutes. The following day, she woke up at 11 a.m. and realized that George was still in the suitcase. So if what Sarah Boone said, if she was truthful in her retelling of the events, George would have been in that suitcase for 11 hours and 48 minutes at the very least. Dr. Lacey, even if he had survived this, what would that kind of an experience be like for someone who, after all of those hours, had been in a situation of being trapped?
Well, not to mention the physical implications, but when we think about the psychological implications, right, there's going to be a lot of PTSD, right, the claustrophobia, a lot of different things that he probably would have gone through, and probably the state of their toxic relationship. All of these things, I mean, it takes him to this edge where she's entrapping him and allowing him to suffer and to beg, and then for him to potentially have survived that, there would probably been a lot of implications to him having PTSD, anxiety, depression, probably a lot of revenge thoughts around this relationship. So we can only imagine what he was thinking in those final moments, because we can hear him suffering and her on the other side of that, to know that someone that you loved has the potential to let you free and to not allow you to suffer, and then to hear her on the other side, I can imagine was very, very difficult for him.
We've got a bit from the autopsy report that lets us know the condition of his body. According to that autopsy, he had long nail scratches to his mid-upper back, a large nail scratch to the back of his neck, contusions to his left shoulder, left skull, and forehead contusions considered to be blunt force trauma. He also had a cut near his lip that was busted. Joseph, just talk to me about what you think the cause of those injuries were. I mean, could he have gotten those just from being inside of the suitcase? Because Sarah Boone told police she was shocked that he had those injuries and said to police, "You don't think that was me, do you?"
Well, that'd be really interesting. When they finally addressed her and began to examine her at the scene and chat with her, I'd really wonder if she had any injuries on her. Again, if he's, say, for instance, if he has any agent on board where he could be compromised, his ability to fend for himself, if he was intoxicated at any level, any drugs on board, she may have been struggling to get him in there, and she's trying to subdue him. That's a possibility. Now, could he have generated those injuries inside of that suitcase just by flailing about in there? I suppose that he could. I'd be fascinated to know what his actual position was inside of the suitcase relative to the floor. And if you could see that image once more of that suitcase, when you see it, I find it fascinating that as you're looking at it, the zipper side of that suitcase is actually down, touching the ground. It's not up. So this thing had to have been moved. The big question here scientifically is, could he have leveraged this thing enough just through the motions of his body to flip it over and it wind up like that? Or did she place him in there and then flip the suitcase so he would not have an opportunity to get out of this thing, perhaps, because he's so disoriented?
Investigators do believe that she was involved in pushing that suitcase over. So the question is, will that be something that she admits to at any point in this trial? We are going to take a break. Don't go anywhere. Our guests are staying with us. We're attempting to answer our next question in this investigation. Just how intoxicated was Sarah Boone when this happened?
You told us you weren't drunk.
No, I was not drunk.
Right.
I was not drunk.
Are you incapable of telling the truth, Brian? On the premiere of Interview with a Killer.
The problem is people don't believe me.
A gruesome torture caught on camera.
You told the police that you shot her because you wanted a Hollywood moment.
The monster behind the memory card murders is speaking out.
That sounds like a guilty man who's coming clean.
Interview with a Killer. Series premiere Sunday, 8/7 Central on Court TV.
I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
That was Sarah Boone on the stand during a previous hearing in her murder trial. She was describing her state of mind during her police interview the morning of George Torres's death. She claimed she was hungover, possibly still intoxicated from the night before. And it's a large point of contention in this case because according to prosecutors, one of the many ways her story is consistent is about whether or not she was intoxicated. Take a listen to how she described her drinking that night in her police interview.
You told me on but you told me on recording that you were not drunk, he was not drunk, you guys were having a good time.
I can't get drunk. Number one, I do not want to get drunk. I don't like being non-compos mentis, having my wits about myself. I don't like feeling out of control. So
I'm just saying you're making it sound like he's a raging alcoholic today, and yesterday I was kind of asking you those questions and you're like a little defensive, like, no, we're not alcoholics.
I'm not.
We are not, but you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out, I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it...
Sunday was one of the better days that we have had in quite some time.
So where were you guys at on drunkenness, not drunkenness on Sunday? You told us you weren't drunk.
No, I was not drunk.
Right.
I was not drunk.
So Sarah Boone has admitted to drinking alcohol, but she repeatedly has affirmed that she wasn't drunk. So that brings us to our next question. Was Sarah Boone intoxicated when this happened, when George Torres was inside of that suitcase? Let's bring back in our guest, still with us, psychotherapist Dr. Jamie Lacey and forensic death investigator Joseph Scott Morgan. Dr. Lacey, you heard Sarah Boone there saying, first, I can't get drunk, and then she says, I won't let myself get drunk. What is that saying to you?
When I hear statements like that, Julie, I often think about clients that we work with that either have some level of alcohol abuse to alcohol dependence. So when there is some level of struggle, then there's also a huge window of denial. So my mind goes to, with that defensiveness, I'm wondering what her history of alcohol was. But when we're watching the video and we're hearing the slurred speech, and we're also potentially hearing the executive functioning going offline, so to speak, and not really thinking through the consequences of her behavior, right? Some of these things are consistent with someone that is at least abusing alcohol, where they're not being consistent with thinking through with their executive functioning, thinking through consequences, and we're hearing her slurred speech. So there would be some assumptions based off of what we see and what we know that there is some level of being influenced by alcohol consumption.
And perhaps what we hear in that video, Joseph, we are hearing her words. It sounds like there's a slur. What are some of the steps that would have been taken by authorities if they would have been able to determine her level of intoxication, knowing that this was the morning after?
Well, if this had been interdicted immediately, I would think they could have perhaps have done a blood draw. But in that same vein, I got to tell you this. And look, I understand that this was not a traffic stop, but I can tell you this: if she had been operating a motor vehicle and police pulled her over, she rolled down the window to communicate with a police officer, and she was speaking like that with that slurring going on, guess what's going to happen? They're going to take her out of that vehicle and they're going to subject her to a field sobriety test, because that in and of itself, just the slurring of the speech, would be enough for them to have reason to do that. And it's fascinating here for me just watching this, because you have this almost in real time, and she's recording herself doing this, and it kind of reaches out into the realm of the absurd. Where she's saying definitively, I wasn't drunk, I can't get drunk, but yet you have her here where her ability to vocalize things is compromised. And so my next question would be, well, are you physically impaired some way? Are you on some kind of medication? Because, this just doesn't sound like someone that has their wits about them.
So Dr. Lacey, she's saying that she can't get drunk. even though we know years after this, her attorneys are going to put down on the record that one of her defenses is voluntary intoxication, hoping to save her life, hoping to get a lesser charge in this case, but it doesn't seem like she wants to admit that. What do you think is the reason behind that? Is there some kind of shame there that she does not want to admit to authorities?
Well, when I hear people say statements like we heard Sarah saying that she can't get drunk, there's usually some context around that, meaning that in my experience, usually when there's some level of those statements, it's because there's some type of history, or people will say, can't get drunk because of this. I can't get drunk because I don't remember things. I can't get drunk because I tend to say things, right? There's usually some type of following statement that people will make, at least in the counseling realm. So when I'm hearing that statement on the video, I would be wondering what her context is, and that would be dealing with her history. Does she black out? Does she normally get violent? Does she say things that she tends to regret, right? So usually when people try to be defensive because they don't want to allow themselves to consume a certain level of alcohol, there's usually because there's a reason behind that, and that reason is something that they don't want to show up in their life. So that is where I would imagine there's some context there to that statement for her and her history.
Joseph, I only have 10 seconds. Do you think a jury will think she was intoxicated?
Yes, just hearing that, hearing the recording, yes, I think that they probably would.
And that's all the time that we have. Thank you so much to our guests, Dr. Janie Lacey and Joseph Scott Morgan, for lending your expertise. We know your time is valuable. I'm Julia Janae. We're going to keep digging for answers as the investigation continues. Welcome to Vinnie Politan Investigates. I'm Julia Janae, filling in for Vinnie as we continue our investigation into Sarah Boone, a Florida woman accused of killing her boyfriend with a suitcase. She's charged with second-degree murder, but she has firmly maintained her innocence for years, going through 8 attorneys and turning down plea deals for a lighter sentence. She says this was an accident and not at all her fault. Here's the story. Sarah Boone and George Torres were involved in an on-again, off-again, tumultuous relationship filled with accusations of cheating and abuse. But on February 23rd, 2020, Sarah and George were together at her home, spending some time together and drinking. But at some point that night, for some reason, George ended up locked in a suitcase while Sarah taunted him as she recorded video with her phone. George tragically died that night, and now Sarah is facing murder charges. There are still many lingering questions in this case about their relationship and exactly why Sarah didn't open up that suitcase and let George out. Now, since the beginning of this case, many of our legal experts have struggled to come up with an effective defense for Sarah Boone in their analysis of this case, especially after seeing that notorious video discovered on her phone. So when Boone landed her 9th attorney, and it seemed like he was the only one who would finally see this case through to the end, we were all wondering what would be his strategy. Then, out of the blue, attorney James Owens made it known he was going to be trying to defend Boone at her trial. The declaration that not only surprised us, but the judge as well. Take a look.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. Right.
Not accident, as they want to allege.
Okay.
This declaration transformed how things develop inside of that courtroom now. So after hearing James Owens' plan for Boone's defense, we're left with one looming question. And it's a big one. We're asking our experts, is battered partner syndrome in this case a legitimate defense for Sarah Boone? And to answer that, let's bring in our guests who are standing by. Joining us, the state attorney for Palm Beach County, Florida, Dave Ehrenberg. Also joining us, the co-host of the very popular Surviving the Survivor podcast, Joel Waldman, joins us on the phone. Dave, let me start with you. This was a moment inside of the courtroom because we didn't expect that this is what she was going to be arguing. We had seen other filings saying voluntary intoxication, perhaps accident, but this is a difficult defense, is it not?
It is, Julia, but this is what happens when you have a client who demands things go her way. That's why she's on her 9th lawyer. She's had irreconcilable differences with the other lawyers because she wants to prove her innocence. Not that she's lesser culpable of manslaughter instead of murder. No, she wants to say she's innocent by way of self-defense. It means she's going to have to testify. But even if you claim this battered spouse defense, it means that you still have to show that you were in threat of your life or at least great bodily harm. Well, she was the one in control here. She was the one taunting the guy. He was stuck in a suitcase. He wasn't a threat to her at the time. And if she really was threatened by him, if she really was that scared of him, why are you playing a game of drunken hide and seek with him? So none of the facts seem to justify her defense.
Joel, you have been inside of the courtroom for arguments leading up to what is going to be this huge trial. What has been the conversation about battered spouse syndrome and whether they can even present it to the jury, because that hasn't happened yet?
Good evening, Julia, and I apologize that you're not seeing me on camera, but I have a face for radio. Better off that you are looking at Dave. I will fix the problem.
That's fine for now, Joel.
To answer your question succinctly, people across the board just think it's absolutely, for lack of a better word, insane. I've talked to a lot of smart legal minds like Dave and criminal defense attorneys, one in particular who just won a battered spouse case out of Palm Beach County, I believe it was, where Dave is. Her name is Jessica Mashali, an attorney, and she said, look, Sarah Boone does not exhibit any of the traits of a battered spouse, absolutely none. She said to me, why don't they just say it was an accident? And you just heard in that soundbite you played that they don't plan on doing that. Why don't they just say that she was drinking, which she was, she passed out, she fell asleep, and next thing you know, she woke up and George Torres was no longer with us. It's obviously a horrible tragedy. But then you got the fact that she also videotaped all of this, which police have, and that videotape, I don't think any jury will be able to get around that.
Yeah, the prosecution does not want this defense coming in. Here's a listen to what they had to say in trying to get the judge to keep it out as an option.
If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, again, she is saying that she did not have malintent at that time. When he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is.
So, Dave Ehrenberg, you hear there the prosecution says you still need an overt act for battered partner defense to work. Talk to us about the difference between battered spouse and self-defense when you don't have to necessarily show a cycle of abuse.
Yes, and by the way, I thought Joel Wallman did a great job, even without video. He's an A-list guest, definitely. And I thought that prosecutor was right on the money. You know, battered spouse offense is not a substitute for self-defense. You still have to show that you are in reasonable fear of your life, and it's an imminent threat. So if she says that, well, he poked his fingers out and he was trying to grab at me and choke me, that would be something. That would be an overt act. But he didn't. He was just trying to get out of the suitcase, and she was the one in control. She was the one taunting him, and the jurors are going to hate this person, this defendant, because she lied to police. She was the aggressor the whole time, and now she's trying to cloak her whole case on this defense that is really not applicable to her. She would have been better served just saying that I got drunk, I didn't mean for this to happen, it's an accident, give me manslaughter, lesser offense, I'll be out in 13 years. But no, she insists on being acquitted, and she's not going to be.
So she's been offered that lighter sentence. She's turned it down. Joel, tell me about what you've been hearing. You're there on the ground. You're also talking to viewers all the time of your podcast about this case. How shocked are people that she turned down a deal which could let her out in the next 8 years or so?
I mean, there's one word, incredulous. People cannot believe it. You know, people don't realize she's been sitting in jail since 2020. She served over 4 years in jail and was offered a plea deal. And people are upset that she was actually offered this deal. She could have been out with time served in something like 8+ years. You could tell that her defense attorney, by the way, this is her 9th defense attorney. His name is James Owens. He said today in court he only got the case 45 days ago. You could tell he was trying to steer her towards taking the appeal, but by all accounts, she's an absolute control freak, and she thinks she is smarter than everyone in the room. If you watch the police interviews, that is abundantly apparent. And because of this, she's going to go to trial, and you know, the betting odds are against her. Most people think she's going to get convicted with a harsh sentence, so I just don't know what she's thinking here.
And Dave, you're there in Florida. You are a prosecutor, state attorney there in Florida. So I'm really trying to dig into battered woman syndrome and how we know that it is a different perception in terms of it's from the perception of that woman who's in this situation. And correct me if I'm wrong, but should we or should the judge be looking more at how Sarah Boone says this all went down? Because she said that she had to hit his fingers with a bat to keep him from coming out of this suitcase. So if she was in fear for her life at the time, she's got this cycle of abuse that she is claiming. And there's some evidence to back it up based on the arrest reports where both of them have been arrested for domestic violence. And a lot of those charges didn't stick. But should there be more emphasis on what Sarah Boone was feeling? There's a look at the filing where the defendant said to her psychiatry evaluator, who said that she shook the suitcase, she lost control, the suitcase flipped, and then she hit his fingertips with that baseball bat that was in the room. Is that not enough?
No, because although you do look at it through the eyes of the person claiming battered spouse syndrome, it's got to be filtered through the prism of reasonableness. Was it reasonable for her to have a fear of her life? The guy was stuck in a suitcase. She was in control. And the little part that he was able to put his fingers out to try to get himself out, and then she had a bat, a weapon. He didn't have a weapon. He was pleading for his life. She was out there taunting him, saying, yeah, that's my name, Sarah, don't wear it out, which is like an 80s line. Shame on her for that. So no, it's not reasonable, and that's the problem here. And one other thing, I know you call it battered women syndrome. In recent years, because any gender could take use of this, it's now called battered spouse syndrome, but it is the same thing. You do look at it through the person's eyes, but it's got to be filtered through the prism of reasonableness.
We are going to keep talking about this case. Our guests are staying with us. Don't go anywhere. We have our next question that we're going to pose in this investigation into Sarah Boone's case. What is it going to be like when she takes the stand?
The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
One of the most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession. 48 hours on Court TV. Coming up next on Court TV. Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
I can't breathe. I thought he was okay.
The Suitcase Murder Trial. Live coverage weekdays, 8/7 Central on Court TV.
The problem is, I fell asleep. We need to do CPR. This morning, when I found it before you called. Yes! I'm gonna stop right now. I was awake, but I actually got out of the bed at like 12:30ish. So I came downstairs, and I was like, oh, he's in the suitcase still.
Throughout the pretrial hearings in this case, over and over again, we've heard a common theme, and it has to do with Boone's upcoming trial. Take a look.
The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
This evidence can only come from her, so she should have to testify.
What does Ms. Boone, in this case, testifies to on the stand?
If the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement, I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative, given her prior statements.
That was defense attorney after defense attorney, making it seem like it's almost inevitable at this point that she is going to be testifying. So we are left with one final question, and that is, what is she going to be like on the stand? After everything we've heard from Sarah Boone, let's bring back in our guest. Still with us, State Attorney for Palm Beach County, Dave Ehrenberg, and on the phone, co-host of Surviving the Survivor podcast, Joel Waldman is with us. Joel, let me start with you. What do you think Sarah Boone will be like on the stand? You've seen her in court, and sometimes she's had to speak up and talk directly to the judge.
Yeah, look, I don't want to make light of this. If you've seen the Suitcase video, as it is now known, it's horrific. George Torres is in there. He is suffering. But she is going to be wild on the stand, and it's going to make for must-see TV. And I hate to minimize someone's loss by saying that, but it is true. I was probably 8 feet away from her today. She's just nonstop fidgeting. She's, just constantly in motion. And her stories are very inconsistent. 1 minute she was saying she was drinking, the next she's not drinking. 1 minute she's saying everything was fine between her and George Torres, the next minute everything was not fine. She can't keep a story straight, and this is a very seasoned prosecutor, Will J., and he is going to trip her up, and she is going to suffer, in my opinion, as a result of testifying, which I think there is no way out of her.
Dave Ehrenberg, this testimony in the narrative style, what is that for in this case? We've seen it in other cases, but it's usually when a defendant is either representing themselves or they told their lawyer something they shouldn't have.
Yeah, that's generally what happens. That's what that case was about in Las Vegas, the Tellis case. We saw it there because the guy was a liar and the lawyer didn't want to be part of it. And I think that when you have so many contradictions, the lawyer doesn't want to suborn perjury, so they just put the defendant on the stand and say, all right, tell your story. And this also shows you that the defendant is insisting on this defense and is insisting on taking the stand and telling her story, looking like it's against the wishes of her lawyer. Her ninth lawyer, as Joel correctly put it. So it will be must-see TV. The jurors are going to hate her. She is someone who's already unlikable without saying a word at the table by fidgeting and talking her lawyer's ear off, passing him notes, and then making demands like Pop-Tarts. She has a diet of a school child. So I think that this is not going to go well for her. She should have listened to her lawyers, but this is how she got to where she is.
So the narrative style means her attorneys aren't going to be asking her any questions. But Joel, when this starts, you've seen her police interviews. You've seen how she seemed to just stick to, how could you believe this was intentional? I didn't do this intentionally. What do you think she's going to be like in terms of staying on task on the stand?
A disaster. I'm no psychologist, but if I had to diagnose her, I would definitely put ADHD in there. And again, I am not a therapist of any kind, but my parents are and were. And, I'm just observing her in court, and Dave is 100% right. She's spending the entire time either taking notes or talking her lawyer's ear off. Yesterday, she kind of swung around and was whispering back and forth from a distance of probably 15 feet because she was in the gallery, but she was talking to the private investigator, and she just cannot seem to keep a focus. And so I think it's going to be really hard. That's going to translate in terms of not being able to tell a story because of this lack of focus. She's going to be all over the place. And again, this prosecutor, Will J., he has been around since the 90s. He's got a lot of experience, and I believe he's going to run circles around her.
Dave, what do you think about this element of her believing, it seems firmly, that this was not intentional, therefore I should not even be arrested? The detective said that, hey, even if it's not intentional, that doesn't mean you didn't do intentional acts that led to this. And the judge is going to keep that part of the interrogation out so that the jury doesn't get confused by that being a legal conclusion. Your thoughts on if that was the right move?
Yeah, it's the right move. The jury's going to see her lie on camera where she said, I fell asleep. And then all of a sudden the videos are discovered on her cell phone and she looks not only like a liar, but a murderer. And so when she tries to have all these different explanations, it's good that the court is going to take control and limit the kind of defenses and the kind of things she could say because, you don't want this to become a circus. It's already going to be a circus if she's allowed to testify in the narrative. She is not going to make a good witness, but at least you've got a judge who has control over his courtroom.
Absolutely. It is going to be a trial that we will be watching every second of. Dave Ehrenberg and Joel Waldman, thank you so much for being with us. We certainly appreciate your analysis and expertise. Now, Sarah Boone's fate in this case, it's going to soon be in the hands of the jury. They're going to decide what happened to George Torres. Was it murder? They'll decide if he was a victim or if she was the victim that night. Looking at the facts and the law is what they are going to be using. Now, she's innocent until proven guilty. It's her right to testify, her right to remain silent. The fact that she's exercising her right to counsel and now has an attorney rather than representing herself means a better chance at fair administration of justice, no matter what side you're on in this case. I'm Julia Janae. We'll keep digging for answers as the investigation continues.
Okay, well, there's that. So let me close that one out. And we will get the court up on screen. As you see, we are waiting for the judge to get into the courtroom. So this is going to be a crazy, crazy trial. It really is. Well, looks like we got some kind of movement in the courtroom. To be honest, I don't know why she didn't take the plea deal, to be honest. But I don't think this trial is going to go the way that she wants it to go. I really don't. Yeah, I can already tell too, Casey. This is gonna be this is gonna be a wild trial. But then I saw some other channels that where things got pretty heated in the courtroom yesterday. I didn't watch the videos because I like seeing them right along when I'm sharing them with you guys. I don't like to really already know what's going on so I can have a raw reaction along with you guys. But yeah, this one's going to be something else. I agree, Casey. I think, just like you said, I think she thinks it's going to be a piece of cake and she's going to be home before long. And I don't think it's going to go that way. I agree. It's very hard with this case because, I mean, we got the video. We've seen it 100 times. There's no denying what was in that video. There's no denying that it was her that was talking and videoing. So, her best bet would have been it was an accident. I fell asleep. I did not mean for this to happen. Because accidents aren't criminal. But she goes down this other road instead, and I don't know. It's as if she's not really paying attention or something, but for some strange reason, she thinks that a jury trial is going to be her best bet. And I mean, with the time that she's been in jail awaiting this trial, she would only have maybe 2 years, 3 years at the most that she would still have to serve because she'd get credit for time served. And then, of course, get credit for good time. She'd only have to serve 85% of the sentence, which she's over halfway there. But she wants her day in the spotlight. That's what this is all about. I really do believe. And to be honest, I don't know why the hell her lawyer. I mean, I've seen some people say that he was really trying to get her to take the deal. But I don't know. But with her getting on the stand, yeah, it's going to be a doozy. And I don't know. Sometimes they make the deal to where they can take it later on and during the trial if things ain't going their way. I don't know if they did it this time. Yeah, she does mine too. Could you imagine knowing her in person? It would really be a scenario, that's for sure. Do you really think that is possible, Casey? With the shit we've seen from her so far? I'm beginning to wonder if she even has that ability. I guess they all still getting their coffees ready. Well, then that might even make her talk more crazy shit. You just never know with that type of stuff. Girl, it didn't take me no time to get my hair fixed this morning. This new haircut, I really do believe it's going to be so much easier than that, the way it was before. I had to plunker with it so much just to get it to look right. It was so long, and I'm like, and it's heavy. Oh goodness, it was heavy. But I think she said it was probably about 8 inches that we cut off. It's supposed to start at 9. I mean, I just saw somebody's head walk by, but I don't know. You know how courtrooms are. They're kind of like the military. Hurry up and wait. Well, they're taking their sweet time this morning, ain't they? There for a minute, I thought it was zooming out, but I guess my eyes were just playing tricks on me. Oh, there's people. So maybe where one lady looked like might have been the court reporter. Or, here we go. All right, court TV. Oh, fun, Casey. At least that kind of breaks up the trial and the craziness that we're going to be hearing in this. Good Lord. Usually they get started in the mornings rather quickly so they can get the housekeeping stuff out of the way. But yeah, but see, this is Eastern time. We're an hour behind them. So it's 9:22 there. I mean, for all we know, they could be in the judge's chamber dealing with housekeeping stuff. But if it's something that's got to be on the record, they have to come out in the courtroom and do it. Oh, this morning, girl, I know what you mean. I'm usually up and going by 5:30 and working. This morning I got up, I think when my feet hit the floor, it was 3:36. So I can relate. Well, that's also got a lot to do with the fact that I go to bed early too. My eyes get so tired by the end of the day from looking at this computer screen all day. My eyes are so heavy that usually by 7, 8 o'clock, I'm toast. And Mike's on this new schedule. He goes in at 5:30 and gets off, or goes in at 5 or 5:30. And he gets off between 3:30 and 4 now. And it just, when he's not here in the evening time, I don't know, I just get so dead blame bored that I just say, heck with it, and I'll go get in the bed. Well, we got a little bit of movement. They need to move it away from the well, right now for us it's almost 8:30. It's 9 o'clock for them. It was supposed to be 8 o'clock for us. They're in Florida. They're East Coast time. Or Central time. So when I moved here from Virginia, I gained an hour. But I don't know where that hour went. We got sound. There she is. Look at her smiling. Well, that was nice of that male officer. Oh, yeah. Even when Mike's at home, where 8:30, 9 o'clock is about the latest I can stay up. Even if I don't get up at 3:30, I'm up by 5:30. So, oh, yes. She loves the attention. And I feel like that's one of the main reasons that she didn't take the plea deal, because she wants her day in the spotlight. she wants the attention, because when she was representing herself, one of the things was, well, I don't know about this. How did the media know about this? So, wow.
I'm ready when you are.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone. Kevin Beck, Sarah Boone.
Oh, she's got 3 lawyers.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's 5th amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel, so on, that necessarily apply to
The sound in this courtroom is horrible.
indicated. I did include certain pages that discuss depression issues, because I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, and maybe relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
Do you speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures. That's still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111, and I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp, so I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there is a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit.
Okay, Casey.
It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologists will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43, it's just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63, it appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. I think it was yesterday or the day before.
He's a lawyer.
That she was aware that they had not been disclosed.
With the secretary
provided,
and a paralegal.
to the state at that time.
So did these records
And
come
he-
in
and they don't
batches?
timestamp
Because my
the
understanding, based on the
relation to a
state's
case?
representation and their objections,
Right.
was that the first 81 pages came on September 27th. Those were provided.
Those were
I
separate. Those
timestamp
were
everything that comes in
records that
relating
some of the
to my
other
notary
lawyers,
work.
one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding, that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Work Advance Billing Department, apparently it's a separate subcontractor, the request would be on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for the receipt of those, so we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and so I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I asked them essentially what these matters were in relationship to, and was told that they already had those records and familiar with them. So I don't think there was any prejudice to the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
Yes, for the purposes of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81, of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was entered as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as
order
page
and
2
the
of
JPEG not
14.
numbered as the
And it
page
appears
number?
to be a part of her visit on January 23rd,
That's kind of lazy
2018.
in my opinion for an
And in the social history
But
provided,
they are trying
it says
to
alcohol
get a
use
lot of stuff done
denies,
in a short
tobacco
period of
use
time.
denies,
But
and the other
yeah.
part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just, at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, amplifier may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seen exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are evidence of prior threats, of prior events of violence committed under that instruction, under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon considering your verdict. You want me to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not inherent. Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on reasonable doubt.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Exhibit A,
Looks-
purposes of a demonstrative aid in opening statement, is a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest. And as you can see, there's blood on her ear, which we believe is relevant or admissible.
Next photo.
This is B. This is Defense Exhibit B, which is a picture of Sarah Boone on the back porch of the townhouse in question with her two dogs. Defense Exhibit C is a blow-up of a picture of inside the townhouse showing the sliding glass door as well as the staircase that leads to the master bedroom and the Defense Exhibit D is a picture of the large screen TV with 6 or 7 holes in it from where George Torres hit the TV with a bat, threatening Sarah Boone. Defense Exhibit E is a blow-up of injuries to Sarah Boone's left arm from George Torres. Defense Exhibit F is a close-up of the wound to Sarah Boone's leg where George Torres stabbed her with a stapler. Defense Exhibit G is a close-up of Sarah Boone's face that shows where George Torres poked her with a curtain rod. Defense Exhibit H is a photograph, close-up of Sarah Boone after she was kicked in the head by George Torres. Defense Exhibit I is another close-up of Sarah Boone's face after she suffered injury at the hands of George Torres. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided the defense in discovery with these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the normal-sized pages of the photographs and then using these as a demonstrative aid to show the jury during opening and then closing the injuries that Sarah Boone sustained at the hands of George Torres.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens,
Yes, sir, Judge, and I sent you some case law along with you guys
when did you send it, sir?
this morning.
I have not received it.
Okay, I think I'm gonna have to reboot
I think we're already on the bench, so we said
my computer it's telling me
State seen a copy of it?
internet is down. Let
I'm
me go
familiar with
ahead
the
and
case law. I
reboot,
did receive the email.
and then I'll be right back
I'm not sure
so we don't miss any of the trial. Okay?
who all was
Thanks.
copied on it.
I'll be right back.
Separate